If you have a pending divorce action, you may find that you're going to need to have a hearing in your case. And there are lots of different types of hearings. So one type of hearing is a temporary orders hearing that we typically have in the early part of the case when you first filed. And the temporary orders hearing is going to help us decide on, those basic issues, the interim issues of, who's going to be living in the house, who's going to be taking care of the kids, who's going to be paying the bills, is there going to be child support, how do we make sure health insurance stays in effect for everyone. And so a lot of times people can reach agreements and don't have to go to court. But if you can't reach an agreement, then that's what the judge is there for. So we're going to go to court and we're going to have an evidentiary hearing. This is very similar to a final trial. And in fact, whether you're preparing for that temporary orders hearing or you're preparing for the final trial, there are a lot of similar strategies that you need to be aware of, especially when it comes to evidence. So the first thing you need to know is that there are serious time constraints. We do not get to go in and just tell the court everything that, could be important. We really have to narrow down and focus on the main issues that are most important. And we're going to need to really limit the information we're giving the court to the most critical information. So you are going to help your lawyer do that by really helping deliver, a detailed timeline. If possession of the children is an issue and you've kept a detailed calendar of, when you've had the kids and when your partner's had the kids, if your partner's had to travel a lot or if you've been traveling a lot, calendars and notes about the schedules is going to be super helpful. So, helping your lawyer really pull together the information is critical. The other thing that we commonly look at to kind of help tell the story is communication between the parties. So you all have shared a lot of text messages or emails. Those can be very helpful. Sometimes people have recordings and, especially if there's been an incident of family violence and, somebody recorded it, that can be really, really helpful information. Now, all the evidence that you have isn't going to be allowed to be presented in court for a variety of reasons, one of which is, like we said, there's time constraints, but then there's also limitations on the type of information that the court is allowed to consider. So we have what are called rules of evidence. And the rules of evidence limit the evidence to that which is deemed to be reliable and can be authenticated. So we can't just come in with a bunch of allegations about what my neighbor told me was happening when I was away that weekend. That would be what we'd call hearsay. So we can't be reporting about what other people tell us. So there are exceptions to that. And maybe we can cover some of those in another episode. But for today, what you need to know is that there are limitations. So make sure you're talking with your lawyer about what are the types of evidence that are going to be helpful. Things like school records and doctor's records are something that we regularly use. But oftentimes to get those admitted, we're going to need what's called a business records affidavit. So, when you start working with your attorney early on, you've identified what the key issues are. You've identified what the key factors are that are going to help the court understand those issues. Then you begin to flesh out what all that evidence is that you're going to use to support. Now, a lot of times in these evidentiary hearings, whether it's a temporary orders hearing or a final trial, we're also going to be bringing in witnesses who have seen you and know your parenting style and maybe know something about the business that's at issue. They can be very helpful people to help explain to the court. That helps validate the things that you're saying. So it's not just a he said, she said. So, you're going to want to pay close attention to who you're calling. But again, we're not going to call in everybody's mom and everybody's brother and sister. And it's just not going to be a good use of the time. So we always want to make sure that those people really bring something to the hearing, really help the court understand what's going on. Sometimes we use experts. And if it's if we're having a business valued or maybe some real estate valued, we need to have the expert come in and testify as to the value. People often wonder, well, can I just have an affidavit? I'll just have the person write a written statement for me and we can offer that as evidence. And that does not come in as evidence. So if there's somebody who knows you and has something important to add, then they're going to need to show up as a witness. Now, the way hearings are being done, oftentimes today, they may be virtual. We may be doing your hearing via Zoom, in which case, we can have witnesses testify remotely. And that's become kind of a normal place. You're going to want to talk with your lawyer about whether that's an option. It certainly is easier and more accessible for witnesses when they don't have to travel across country to come testify. But if we're in person, then most likely any witnesses that you have are going to need to be in person. So those are just kind of an overview. What happens in a hearing? And, people want to know how much time will we have? And that's going to vary from court to court, from county to county, and judge to judge. So that's just going to depend on sort of what the customs are. Temporary orders hearings can be 20 minutes aside sometimes. Full trials can be several days. So that's just going to depend on the nature of the hearing and who's in control, who the judge is.